BWF Solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Hello, ladies and gentlemen. You're welcome to Heritage TV, hanging out with Vicky. Oh dear, I hope you are all keeping well. Today is another day. Today, our show, we have BWF solicitors with us in the studio, and we're going to talk about applying as a child under the 7-year route. What is it at all? How do you go about it? What are the requirements? We are going to talk about all those. If you want to contribute to the program, please send your questions to us on all social media handles at Heritage TV. Please contribute and share. This program is sponsored by Victon Estates, your one-stop property professionals. If you want to sell your property, you want to rent your property, you want your property to be managed, look nowhere else but Victon Estates Limited. You can find them online at www.victonestates.co.uk or give them a call on 0744 8619 711. The second sponsor is Eagle Heights International School. It's a very reputable education company teaching children mathematics. If you want to get in touch with the team, the number to call is 075 437 07121. It's 075 437 07121. And of course, our legal partners, BWF Solicitors. So I'm not going to waste much of your time and introduce you to our lovely lawyer, Eunice Achampong, a partner with BWF Solicitors and also a solicitor. Hello, lawyer Eunice.
Hello, Vicky. Hope you're doing well.
Yes, I am. And before we start the show, on behalf of Heritage TV, we want to send our condolences to you for the loss of your auntie. So please have our condolences. I know you are paying your respect to your auntie who is being buried today, but your commitment to our viewers. You make sure that you come to us and also, educate us on legal issues. So we very much appreciate it. Please have our condolences.
Thank you so much, Vicky. She was a wonderful woman throughout my life. She's obviously grown up with my mum and her siblings, and even before I was born, she always used to literally speak to me, and she would tell me things like, don't neglect God. She actually was one of the people that introduced me to something that we call Vacation Bible School. And when I was a little
Right.
child, she took me to one of those, and that's where I received the Lord. And she will always be concerned about your academics as well. She'll be like, study hard, work hard, make sure that
Mm,
you are
mm,
not lazing about,
mm.
make sure that you're doing well in school. And she was one of those people with just an amazing heart. Some years ago, she was sick with cancer, and she was
Okay.
obviously battling with other health issues. But
Okay.
it's amazing how she was able to go through that and still complete a master's degree and do other postgraduate degrees
Wow.
in addition to all of that. And when I see her and I listen to her, she is always speaking words of wisdom, and I truly thank God for her life. And I know that she's one of the people that I will forever cherish in my heart. She had
Mm, mm,
a
mm.
daughter who is about 12 years old, and her daughter says, "No,
Okay.
mommy, I know that you were in so much pain, but we thank God for the fact that you were here with us, and we know that you're going to be with the Lord." So I'm so grateful for knowing
Oh.
somebody like her. She's Mrs. Christine Manfoswa Tete Ashong. And so I pray
Okay.
that the Lord will keep her family and that she will
Mm.
also rest in perfect peace. Thank you so much for
Amen.
allowing me to
Amen.
have
Amen.
this time
Amen.
today.
And I know she's going to be so proud of you being, coming out being a seasoned, solicitor. She is definitely going to be
Yes,
very proud of you.
yeah,
Yeah.
very, very, very.
Yes, well, Eunice, now going back to what our topic is today. Applying as a child under the 7-year route. Give us
Mm,
a little brief. What is this all about? Because a lot of people get it confusing when it comes to when the child is 10 years.
yeah, yeah.
Some didn't
And
know that
so
there was
the last
something known as the 7-year route. So, yeah.
the last time we were doing the program, we're looking
Yeah,
at something called applying for leave under the 20-year rule. So
20.
basically,
Yeah.
people who've lived here for 20 years can make an application. And this time, we're
Mm,
looking at it
mm.
from a child's perspective. So under
Perspective.
our immigration rules, we have that section under paragraph 276 ADE, and it's a
Okay.
continuation of applications that can be made based on private life. So you may not
Okay.
necessarily be making the application with a family member, but based on your own life. And so, in cases where we are talking about making an application under the 7-year route, we're saying that, or the immigration rules is saying that you can make an application if you are a child who is under 18 and you
Mm,
have lived in the UK continuously for a period of 7 years. So, a child who maybe has lived here continuously for that period of 7 years will be, we'll have parents who don't even have leave to remain, but that child, because they have lived here continuously for that 7-year period, can make an application for leave to remain where he would be granted or she would be granted 30 months leave to remain accordingly based on their own private life. So, in cases where that child may be traveling and you think, oh my
mm.
goodness, what can I do to get something so that my child is able to travel? Things like this will be one of the first things you'll be taking into consideration when
Okay.
you are thinking about that child as well. So it's part of the private life applications under 276 ADE, and it's one of those
Okay.
applications where the Home Office have a discretion to grant
Mm,
uh, the leave of 2.5 years or 30 months for that child
okay.
to continue to remain in the UK. Yeah.
Okay, Laura Eunice, how about those who have their children here, take them
Mm,
back home? Probably the child will go to nursery in Ghana, then come back
mm,
and join reception, starting primary.
mm, yeah.
Such a child will such a child apply or would such a child be eligible to apply under the 7 year route, or it applies to those who don't live in Ghana for a certain period of time, maybe go for a visit, come back, go for a visit and
Mm,
come back. Just can you
mm,
please explain? Because we have parents who do that a lot. Maybe it's because of childcare; they weren't able to bring their
mm,
parents here to help with childcare. So to
yeah,
enable them to, do full-time work, they will prefer
yes,
taking the child back until the child is
back.
prepared to ready to go to primary school. Then they bring the child back in.
Okay, so in cases where, for instance, the child has, for one reason or the other, lived in another country and they've now been brought back, as long as the child is still under 18, they're going to be looking to see whichever country they were living in. The child has now lived in the UK for a 7 year continuous period. So, if, for
Mm,
instance, let's say that the child has been in and out of the country because obviously there's childcare issues. So since they were born, they were just in and out, and finally they returned to the UK sometime in 2010. Since 2010, they've obviously lived here. Um, if you're saying that that child has lived here continuously for a 7 year period, then obviously that child can make the application based on 76 ADE to say that they've
okay.
lived here continuously for a 7 year period. And so they will be counting from the time the child last entered and continued to live in the UK.
Mm,
So once
mm,
you are able to say yes, the child has lived here for a continuous period of 7 years from the date of the application, then they can obviously consider that child. And there are certain factors that the Home Office will take into consideration when they are
okay.
looking at
Okay.
such an application as well. So one of those
Okay.
things could be the fact that this child is under 18, is living in the UK.
Mm,
They'll also have to
mm,
consider the child's best interest as well. And so when you say the child's best interest, we're saying that the child's interest should be made paramount. It's not going to be the only consideration, but it should be made primary. It should be made primary consideration in the assessment that the Home Office will be making, whether it will be reasonable for child, for instance, to be returned back to their
okay.
country of origin. So all these
Mm-hmm.
factors will have to be taken into consideration once that child makes an application for leave to remain to the Home Office.
Okay. Brilliant. Okay. So what is the Home Office looking for when considering such an application?
Yeah,
The
so some of the
necessary
things,
documents to provide. Yes.
yeah, so some of the things that I mentioned. So, for instance, you're saying that your child has lived here continuously for that 7 year period at the date of the application. So, you are also going to be adding things like the school letters, any GP letters that they may have, um, any sort of proof of address to show that since they came
Okay.
into the country, they have been living here continuously. And also, some of the factors that the Home Office also look at was one of the things that I mentioned, whether it will be
Mm,
reasonable for that child to leave the UK, and if it's not going to be reasonable for that child to leave the UK, factors that they will also consider is that the best interest of the child, which is
okay.
something that is legally binding on the Home Office to do, because under Section 55 of the Borders and Immigration Act, they have to consider that child's best interest. So
First,
the
yeah.
child may have lived here continuously for that period. They've probably lost ties with friends at home. They
Mm,
now know the UK to be their home. All their friends and everything that they know is here in the UK. Their family is here in the UK, for instance, and there is nothing that they will be going back home or back to the country of origin to do, because maybe they don't even know how to speak the language. They have no social ties, no family ties whatsoever. So all of these things the Home Office will have to consider, and it is up to the child and the child's parent to put that across. So if the only spoken language of the child is English, obviously English is the only language that they know how to speak. If the child has friends that can write letters of support, because children,
Wow, at
they're
that
so
age.
honest in what they think. They're so honest. This is my best friend. We do everything together. You
Yes,
can add those
yes,
letters as well. If they play a role in some extracurricular activity or club, those clubs or those extra activities,
yes,
institutions
yes,
or authorities can also write
yeah.
letters in support. We
Like
know this child.
brownies and all those. Yeah,
Yes, all
yeah,
those
yeah.
organizations, they can all write letters in support to say that this is a child who is very active. She's very together, bringing all sorts of people together. And all those letters help in building that case of it's not going to be reasonable for this child to leave the UK, because now they know and have established all their social ties, all their should I say communal ties, and everything that they know is here in the UK. The UK is now their home, and they cannot imagine being anywhere else apart from being in the UK. So if the church, is able to also support and writing a letter, definitely let them write a letter in support of that application as well. And so all these things are factors that the Home Office will take into consideration when they are looking at an application for a child under the 7-year route. And I think that
Okay.
a lot of the time, people who are making those applications should definitely seek legal advice and support when making those applications, so that at least they know that they have a better chance of being successful in those applications
Successful.
as well.
Okay.
Yes.
All right. Okay. Well explained. Right. I think the questions have started flowing in. May I remind all those watching us that we want to hear from you. We need more questions coming in. So please, 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 please send your questions to us on all our social media handles. We are live on Facebook, YouTube, and all other social media handles. So please send in your questions, because I know when we advertised this topic on our social media handles, people were so keen to join in this conversation because it's so dear to their heart. So I entreat everyone to send in their questions, their experiences, and any contribution on all our social media handles. The first question that I've received, it says, I have lived in UK for 10 years and arrived with my daughter when she was only a toddler. Can I make an application for leave to remain for both of us?
Okay, so this is similar to what we were asking before. So a child
Yeah.
who obviously has just come from abroad and wants to make an application. And this time it's not just the child, but the mother also wants to make an
Yes.
application, or the father wants to make an application in addition to this child as well. So usually when the application is being made for the child, as I said before, it will be made under paragraph 276 ADA of the immigration rule. And then obviously we have the parent. When you look at our immigration rules, we have a section called Appendix FM. That is to do with parents, child, spouses, and any adult dependent relatives. And so this parent is basically making the application based on the fact that this child has lived in the UK continuously for a period of 7 years. So under Appendix FM of our immigration rules, it says under the parent route, or under the immigration rules for a parent, that if an application is being made by a parent, they are making the application because they are in the UK, and they are making the application based on a child who is under 18 and has lived in the UK period of 7 years, or that child is British. In this case, if the child is not British, that means that that child has lived here for a continuous period of 7 years. And then you have cases such as KO Nigeria and ET and PT, where parents have been able to successfully, through the tribunal system, say that even though maybe they have adverse immigration history, maybe their immigration history is not great, they've made different applications upon applications, they have been unsuccessful, maybe they even have criminal past, but because they have children who have lived here continuously for a period of 7 years, they have been able to rely on those children to make applications such that obviously the tribunal or the court has found it fit that they should be able to rely on that qualifying child to make an application for further leave to remain in the UK.
Amen.
So
Okay.
based on this child who has lived here continuously for that period, that child is saying that they cannot return back to that country, or it is unreasonable for that child to return back to their country of origin. They know the UK as their home. They know that there are no social ties, no family ties whatsoever back in the country where they may be coming from, and therefore they would have to make an application for leave to remain
Okay.
based on paragraph 276 ADE. And that parent will also be making that application together with the child who is 7 years old. So the parent is saying that they are relying on this child's application because obviously they have that parental relationship. They are able to show that no parental responsibility for that child, or that they have direct access to that child, and that child has obviously lived here continuously for 7 years before the date of the application. And so once the Home Office is considering that child's best interest, they will also be considering the fact that they have a parent who is in the UK who needs to also
UK,
care
yeah.
for this child. And without that parent's support, it will be difficult for that child to be brought up here in the UK. So those are some of the factors that the Home Office will take into consideration. And that's one of the good things about having these court cases as well, because it makes
Okay.
it clear that sometimes there are certain considerations that the Home Office has to have or put in mind in terms of children who have lived here for that continuous period. And I know a lot of people also were thinking those applications, because it was a discretion to the Home Office to either grant or not to grant, they used to not do it until the child is about 10 years old, like you said.
Yeah.
They would
Yeah.
wait until the child has reached the age of 10 before they would even consider making an application for themselves or for the child. And now we have all these cases, like I mentioned, KO Nigeria and ET and PT. And so these cases mean that now the Home Office have to consider all these other factors and make sure that because the child has nowhere to go apart from being in the UK, regardless of those past or adverse history that the parent may have, they should still be able to grant further leave to remain for the child and their parent.
Okay. Okay. All right. Brilliant. Our next question. My partner and I have lived here for over 15 and 18 years, respectively. We had our 3 children in the UK, and our eldest child is now 8 years old. Can we regularize our stay in the UK?
That's an interesting question, because now you have both parents, and then there's a child who is obviously 8 years old who has lived here continuously for that 7-year period. But now you have an additional 2 children who want to also make an application in
Yes.
and turn with the parents as well.
Yeah.
So in this scenario, the child who is now 8 years old will have to prove that they have lived here continuously for that 7 year period. And so at the beginning, I will say that they will have to make sure that they include things that they have lived here for that 7 year period, which will include school letters, GP letters, or any hospital letters, letters from extracurricular activity or clubs or organizations, even friends of the child can write letters to show the impact that the child has had in their life. And if they do have attend church or mosque or whatever it is, those institutions also can write letters in support of the application. So once the child has been able to show that they have lived here continuously for that 7 year period, then the parents will also making the application to show that they are parent or parents to this child. They have joint parental responsibility for this child.
Ability.
Also,
Okay.
the fact that they are able to obviously show that because this child has lived here continuously for that 7 year period, maybe they don't even have any knowledge of the parents' country of origin. And so,
Okay.
because of that, they would like to make an application to regularize their stay or to be granted further leave to remain because of that child. And
Okay.
usually, they will also consider all these factors, the factors that, for instance, the parents are living in the UK, they have siblings living here, if they have other extended families, the fact that their extended families are here, if the child hasn't got any knowledge of the country where they are supposed to, should I say, leave to, then they would consider that as well. And then the language as well. So maybe a lot of them do not even know how to speak the language that their parents speak. And so
Speak. Okay.
that all, yes, that also will be taken into consideration. And if they have no ties whatsoever and they've established family ties in the UK, they have established social ties in the UK, and the fact that they also have the only culture they know is the one they know in the UK. They have no
Okay.
other ties apart from the ones they have formed here in the UK. And
Right.
those are some of the things that they will be looking at in terms of such an application. And then the children, in addition to the parents, are showing that because their parents will be granted further leave to remain,
Leave to
they
remain.
also should further leave to remain under Appendix FM as children of a parent or a parent of a qualifying child. So it's good for the family, and especially, like I said before, cases that have gone through the court system like KO Nigeria and ET and PT also have cases to do with families and how these families can also rely on the fact that their children have obviously lived in this country for that continuous period of 7 years, and it would be unreasonable to say that those children should now uproot their whole lives to a country that they have never known, to a country
No.
where only their parents know, and probably their parents have lived here for several years, and in this case 15 years. And so it's almost as if you are telling these parents that, do you know what, we don't care how long you've lived here, just uproot your whole family and go home with them. But it's not the case nowadays because of these cases, because obviously at certain points in time, if you don't challenge the Home Office in regards to these issues, they take certain things for granted. So we are grateful for these cases that have gone through the tribunal system, and it's making us more aware that children who are aged 7 or who have lived here continuously for that 7 year period can now make these applications and also be successful in being granted further leave to remain. And there were circumstances prior to this where you would have to show maybe that the child had some exceptional circumstance, like they had some
Circumstances.
illness, or there was
Okay.
something that was fairly, should I say, exceptional about these cases. But now there isn't that, should I say, that principle of looking at exceptional circumstances in regards to
Any,
family
yeah.
application, or in regards to this
Okay.
child who wants to apply for further leave to remain because they've lived here continuously. So that rule of exceptional threshold or whatever it is, it's no longer there. There isn't that particular exception. And so I am so happy that at least these court cases have come up and have made people more aware that these applications can now also be looked at and also be given the due, should I say, consideration that they should be given, just like somebody who is applying as a British child or applying because they have settlements in the UK. Yeah.
Okay. Laura Eunice, just needs a little bit of a clarification. So for a child applying under the 7-year route, does that mean the child's parents do not have their stay? That's why the child is applying under the 7-year rule.
Yes. So usually,
Right.
if the
Right.
parents, for one reason or another, so maybe the parents may have 2.5 years leave to remain, and then
Okay.
for A, B, and C reasons, they have a partner, and this partner has his own child, and so this child of the partner hasn't got leave. This child also hasn't got leave, and so they are looking to make an application for this child. Because this child is a stepchild, the only routes that
Okay.
will be available will be, let's say, living here continuously for a 7-year period. So that child will have to make the application. Whereas if the parents were settled or British, all they need to do, either that the child was born before they had settlement, and so they will be applying for British citizenship or British passport for
Exactly.
that child.
Yes.
And then if
Yes.
the child was born after they had settlement, then they'll be applying for British citizenship for that child. So they'll be registering the child to be British. He will have a certificate, and then he will apply for the British passport. So in those scenarios, that child would not have to apply for leave to remain based on the fact that they've lived here for a continuous period of 7 years. So in scenarios where a child is applying, either that their parents are not alive or their parents may be alive, but they do not have leave to remain for that child to be able to regularize their stay in the UK.
Okay. Okay. All right. Brilliant. Now, Eunice, I realize in your explanation for our question, I think your throat was a bit dry. So I'll take the opportunity to go for a commercial break and to enable you to have just a glass of water, and we'll be right back.
Thank you.
Ladies and gentlemen, let's just take a quick commercial from BWF Solicitors, and we'll be right back. Lawyer Eunice needs a little bit of water for her throat.
BWF Solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence, and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Thank you, ladies and gentlemen, for staying with us. This is Hanging Out with Vicky on Heritage TV, and today we are discussing applying as a child under the 7-year route. And with us today is our learned solicitor, lawyer Eunice Achampong from BWF Solicitors. We just quickly took a break to just, have a little bit of water. Lawyer Eunice, are you feeling much better?
Yes, I am. Thank you so much.
All right. Okay. Right. Brilliant. Yeah, Lawyer Eunice. I've got another question which says, what are the chances that the application under this route will be successful? As I previously made such an application 5 years ago, and I was not successful with the application.
I think that a lot of what I was even saying before is because a lot of it had to do with the Home Office using that discretion and then looking for exceptional circumstances. If, for instance, that child had some sort of health issue or disability or something that they could use to say that because of these exceptional circumstances, we will grant this child further leave to remain.
Okay.
And 5 years ago, we didn't have those cases such as ET and KO Nigeria, where they had gone through the court system. These cases came up sometime in 2018. So what was useful about these cases was that then it made it took like a huge burden off people that wanted to make these applications, but were thinking, do I have to wait 10 years until my child is British before I can make this application? I want to work, and my child may be like in the case where the child has to travel, and you are thinking, how is my child going to go on that school trip and all of that? And so it was a huge burden that was lifted off when these cases came out in 2018. And it made the Home Office now implement it into their policy, because a lot of the time, apart from the law, the Home Office have their own guidance or their own policy when they are assessing or when they are considering applications. And so it made them now implement these court decisions in their own policies and in their own guidance, such that now it should be taken into consideration that children who have lived here continuously for that 7-year period will now have to they will now have to make sure that these children's best interest is of primary consideration. They will have to consider factors, like I mentioned before, that would make them assess whether it would be reasonable for that child to return to the country of origin where maybe their parents are from. And those factors have to be considered, weighing in that the child's best interest is also at heart. And so, if they have evidence to support the fact that, yes, this child has lived here continuously for a 7-year period, yes, this child has formed family life in the country, in the UK.
Yeah.
And then again, the fact that this child has also formed social ties with friends, with their community, maybe with
Community.
other children within the extracurricular clubs or organizations. And therefore, this child views the UK as their permanent home. They don't even know the language back where their parents are from, and they
Yeah.
do not even understand the culture. So the only culture that they know is the one that they have here in the UK. And so all these other factors, the fact that the parents are also here and their siblings are here and also extended family,
Yeah.
all these factors have to be taken into consideration. And so when the Home Office is looking at those applications, they have to consider all these factors and the fact that because of these cases, it shouldn't be looked at as whether they would grant it if there are exceptional circumstances, but they should be able to grant further leave to remain, having considered these factors and the fact that the child's best interest should be made primary consideration. Yeah. So
Okay.
it's one of
Laura,
those. Uh, I
yeah,
was just
go
going to
on.
say
Go
it's
on,
one
Laura
of those
Eunice.
cases. It's one of those cases where you have to obviously be able to show by way of evidence that this is what it is. And so, if you have provided all the evidence which is sufficient to show that because the child has lived here continuously for that period, and maybe you as a parent have been responsible for this child, maybe since
Child.
they
Yeah.
started living here, or maybe, yeah, sorry, since the child started living here, or maybe since the child was born here, then you should be able to provide all of this and should this child needs the parent here in order for them to continue their family life here in the UK. And I was going to just mention that one of the things that we mentioned the last time was the fact that there is that right to family life as well, and
Yes.
that's protected under Article 8 of the European Convention on Human Rights. And so, if you have that respect to family life and you haven't been, as a child, the child would not have, should I say, breached any immigration rules, and they haven't
Rules.
done
Yeah.
anything to obviously show that they are not a person of good character, then it is one of the things that the Home Office will consider, and they would be able to say, yes, all these factors are things that we've considered, and therefore we would grant this child further leave to remain in accordance
Okay.
with the immigration rules and also their parents as well, regardless of whatever adverse immigration history that he or she may have in relation to their own issues. But in consideration, the child has lived here for continuously for 7 years, and this parent has been responsible for this child, and therefore we will grant them further leave to remain. So
Okay.
it's a positive thing that these cases came out in 2018, just so that the Home Office could, should I say, amend their policy and make it more in line with those who are applying based on the fact that they have children that are British.
Okay. Laura Eunice, with the child being 10 years and naturalizing to become a British citizen, as compared to applying under the 7-year route, which one is straightforward and easier, and which one is, if you look at the success rate, is it the 10 years
Mm,
naturalizing to become a British citizen, or applying as a under the 7-year route?
mm. So if you ask me this, like before 2018, I would have been saying, yes, when your child is 10 and you register that child to be British, definitely it gives it more of a solid ground, because you have previous cases that have gone ahead and said that because that child is British, they have that right to reside here in the UK, and those applications would usually be looked at more favorably in terms of the case laws that have gone before it, and because of
Yeah.
the fact that
Yeah.
the Home Office's own policy said that in such cases it would be unreasonable for that child to be returned to their country of
Okay.
origin. Yes, those were the times when they would have said that, but now that we have these new cases, I don't think that they have to be looked at in any should I say with much difference whatsoever. Just because the child British doesn't mean that the child who has lived in continuously 7-year period would be looked at differently because of these new case laws and the fact that it's now been implemented into their own
Yeah. Yeah.
policy. Once you are evidences to show that yes, this child has lived here for this continuous period. They have formed
Okay.
family life here. They have formed social ties here. They've established the UK as their main or permanent home. And all of these things are things that Home Office have to consider. And
Okay.
therefore,
All
I
right.
would not say that making an
Okay.
application based on the 7-year route
Yeah,
is
route.
less favorable
Let's.
than
Okay.
somebody who is applying for
For the
applying for leave
naturalization. Okay.
based on the child who has naturalized or who is
Okay.
British. Yeah.
Okay. All right. Well explained.
Yeah.
Yeah, Lawyer Eunice, because of time, let's quickly go to our last question. If the child applies under the 7-year rule and is not successful, can the child apply again when they are 10 years from naturalization? I think the person was listening
So
to the previous question I asked.
yes. So if the child wasn't granted leave to remain based on the 7-year route,
7-year route.
definitely once the child is able to attain the age of 10, you can make the application for them to be registered as British. And then once
Okay.
they receive their certificate, the parent can then make an application for further leave to remain based on that
Okay.
child who is British and living in
British.
the UK.
Okay.
So obviously, in a case like this, I'm sure there isn't much time until the reaches. I'm sure once they made the application, it took a while until they had a response, and now the
Yeah.
child is almost 10. So if the child is almost 10, there's no point making another application for further leave to remain under the immigration rules because the child is almost 10. So you might as well wait until the child is 10 and then make the application.
Yes.
If the child were 8, I would have said make another application for further leave to remain. They would definitely.
Oh, okay.
But if the child is almost 10, then definitely they can wait until the child has attained 10 and then register the child to be British and then make the application.
Okay. All right. Yes. So, Lawyer Eunice, I think we've exhausted this topic. If you could quickly give us your last words and contact details, anybody who wants to get in touch with you and probably would like their children to apply under the 7-year route.
Good. So, I work for BWS Solicitors, as you previously mentioned, and BWS Solicitors is situated at Seven Sisters. So we're very, very close to the Seven Sisters tube station. If you're coming from exit 2, we are on the right-hand side of the exit, a large building called Anna House. If you're coming by car as well, we have parking on the adjacent road, which is West Green Road, and there's also 1 hour 30 minutes parking at Tesco's as well. And we where our address is the 4th floor of Anna House. So 4th floor, Anna House, and it's 214 to 218 of the Tottenham High Road. It's London, and then the postcode is N15 4NP. Our offices are open from Monday to Friday from 9:30 to 6 p.m. and our 8-493-7340. So 0208 7840. And my personal number out of office hours for you to contact me if you need any further explanation or you need help with the application. You can call me on 075 35 81 3910. So 075 35 81 3910. So yes, Vicky, hopefully we should have
Thank you.
another topic next week as well.
Exactly. Thank you so much, Lawyer Eunice, especially taking, time off, going to pay your last respect to your auntie, to be with us and share, your expertise with us. We very much appreciate it. So send my regards to the family, especially Auntie Helena. I'll give her a call, later on today.
I'll let her know.
And also send our regards to the BWF team, especially Mr. Bernardo Wusu. Send our regards to him. Have a lovely day, Lawyer Eunice. Yes, viewers, so there you are. Today we've discussed applying as a child under the 7-year route. And I believe we did justice to this topic. The questions that came in fact, explained it into detail, what, we should look out for when applying under the 7-year route. So on that note, I would like to say a big thank you for staying with me throughout the show. I will be back at 1:30 p.m. with Amma Cares to talk about depression after sexual abuse. So please take note of that, and I hope to see you again at 1:30. Take care of yourself, keep safe, observe the government guidelines, and always, cover your nose and mouth when you are out and about, and, sanitize your hands at all times. See you later. Take care.
BWF Solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.